Welcome to the LawGH channel and your second lesson on Ghana legal system. Today, we're treating the topic classifications of law. The classifications of law is so much of a fundamental area of the law that everyone needs to learn, appreciate, and understand because it serves as a point of reference, a ground for certainty and predictability to our laws in the legal system. You'll get to know the need for classifying laws after you stay throughout with us in this lesson. Before we commence, to ensure that our viewers grasp the understanding of this topic, let us lay down the cardinal areas we will study and the classification of law in this video. In order to fully appreciate and understand classification of law, you need to look at the following. A. What is classifications of law and how are laws classified? B. What are the types of classifications of law and their features? C. Where two classes of laws overlap, how does the application of the laws resolve itself before the court? And D. The essence of classifications of law. As we are about examining these cardinal areas seriatim, please do well to kindly click the subscribe button to subscribe to this channel, write down your comment, like this video, and share to everyone. We do appreciate your time with us, O Lord. Let's begin. A. What is classifications of law and how are laws classified? In order to know what is meant by the classifications of law, you need to first of all have a general idea of what is law to enable you gain the idea of what are the classifications of law and how they are classified. We will later in our lessons treat the topic, the nature, scope, and functions of law. In that lesson, we will try to help you understand what is law. Classifications of law are the different categories into which all areas of law can be collated. A particular classification of law encompasses all types of law, but it distributes them according to a particular unique characteristic. Thus, the laws are grouped into branches based on certain traits the laws demonstrate in common. Concerning how laws are classified into branches, there is no definite way in which laws are classified. Anyone could classify laws into whatever way depending on the focus of interest and the piece of information intended to be conveyed. However, some people choose to classify laws into about 6 to 12 branches, namely public international law and private international law, civil and criminal law, substantive and adjectival laws, international and municipal laws, written and unwritten laws, and lastly, common law and equity. For a purpose and to simplify the study of this topic for our viewers, the next section below will show how we intend to classify laws. B. What are the types of classifications of law and their features? We intend to classify laws into 3 main branches, and these are the international law, the municipal law, and the substantive and adjectival law. Let us now examine some laws and the characteristics associated to these branches. 1. The international law branch. International law is concerned with the external relationships between different states and is based mainly on treaties or conventions, and international customary law, including general practices as widely accepted by the various legal systems. See Article 38 of the ICJ Statute. Examples of laws under this branch include the Vienna Convention on the Law of Treaties, the UN Charter, the Constitutive Act of the AU, and the Treaty of European Union, also known as the Maastricht Treaty. Thus, any laws that governs the relationship and operations between 2 or more states will fall under this our branch. The obvious categories of laws under this branch are public international law, international trade and investment law, and partly of private international law. 2. The municipal law. Municipal law comprises the laws in a legal system of a particular state, that is the cases or statutes law which govern relationships within that country. Thus, all the laws that exist in the country and does not govern another country but only in that country will fall under this branch. The municipal law branch could be further divided into 2 sub-branches, namely public law and private law. Public laws are one of those laws in which one of the parties to the dispute is the state, usually acting through a government ministry, department, or agency, while private law is concerned with the rights and duties which private individuals have in relation to each other, and the state has nothing to do with that. It is under public law that we will find constitutional law, administrative law, law of taxation, and then criminal law. With a sub-branch of private law under the municipal law, the rights and duties which private individuals have in relation to each other are the subject matter. Under this, there are many different categories. For example, the law of contract, the law of tort, wrongs such as negligence, defamation, or trespasses, company law, commercial law, and the law of property, movable and immovable properties. 3. The substantive and adjectival laws. Laws could also be categorized into substantive law and adjectival law, which is also known as procedural law. Glanville-Williams, in his Learning the Law, explains that substantive law is the term which is used to refer to the rules which govern our rights and duties under the law. For example, the cases and statutes which create criminal offenses, or the cases and statutes which define contractual obligations. Street Feder explains that substantive law embraces all those provisions which relate to the rights either of individuals or of a group or society at large, and of the wrongs which infringe such rights, while adjectival law has to do with the rules under which these rights are vindicated and these wrongs redressed. Adjectival laws prescribe how those substantive rules can be used within the legal system. For example, the rules of evidence, procedure, and cost, which are to be observed when bringing a case to court. In sum, procedural law is the body of legal rules that govern the process for determining the rights of parties. The contrast is exemplified by Act 29 and Act 30 in criminal law. The distinction and importance of this distinction is seen in cases such as Jacob Zuma and NDPP, and Republican ex-party Shraj Richard Anani interested party. At this time, in identifying the characteristics associated to these branches, it is prudent to highlight that all the categories of laws under the private law are considered as private civil laws, whereas the categories of laws such as the constitutional law, administrative law, and law of taxation under the public law are also considered public civil law. Thus, this simply gives us two broad types of categories of laws under the municipal law, which are the civil law branch, public and private, and then the criminal law. Let us now see the characteristics of these categories to be able to distinguish civil law from criminal law under the municipal law. The characteristics and distinctions between the civil law branch and the criminal law branch are manifested in context of the case, the purpose of the action, the parties involved, the standard of proof, the potential resolution, as well as the forum or court. Some of the characteristics are as follows. 1. Substance of the case. The whole context of the case is different. The criminal law involves the regulation of behavior that is unacceptable and considered as offenses to the state, while civil law involves the resolution of disputes between two parties to settle the release claimed against each other. For instance, in the case of contract law, which falls under civil law branch, a dispute whether there is a valid contract binding the two parties, see the case of NTAC and NT. In criminal law, whether the celebration of 31st December as a public holiday is inconsistent with the Constitution and thereby null and void. However, in criminal law, the substance of the case could be on the stealing of one's property. 2. The purpose of the action. In criminal law, the purpose is to preserve order in community, deter subsequent offenders of the law, and emphasize the state's position of frowning on the commission of crimes. Civil law, on the other hand, seeks to regulate relationships and settle disputes. For instance, a breach of contract or a breach of a duty of care owed to another. 3. Parties. The parties are completely recognized distinctively. In criminal law, the state is a party and prosecutes an accused person, Whereas in civil law, the parties are referred to as plaintiff and defendant, or petitioner and respondent, depending on the case, and a defendant answers a claim from a claimant. 4. Procedure. Under criminal law, the processes to follow in prosecuting an accused person is different from the processes to follow in civil law actions. Criminal law is usually commenced by either a charge sheet or bill of indictment or by a warrant of summons. See the Criminal Procedure Act of Ghana 1960, Act 30. Whereas under civil law actions, commencing an action against another is usually by a writ of summons, or a petition, or an originating motion. See the High Court Civil Procedure Rules 2004, CI 47, and the Court of Appeal Rules and the Supreme Court Rules as amended CI 19 and CI 16 respectively. 5. Standard of proof. The standard of proof is also different. In criminal law, because a defendant's life or liberty may be at stake, the prosecution must prove the case beyond reasonable doubt, but in civil law actions, the claimant has to prove his case only on a balance of probabilities or the preponderance of probabilities. See sections 10 to 17 of the Evidence Act and RCD 323. 6. Resolution of the action. A successful criminal trial results in a conviction and subsequent punishment if found to be guilty of the offense committed, or acquittal if found not to be guilty of the offense committed. The punishment generally is in the form of imprisonment and fine. Note that the criminal offenses and the punishment to be charged and imposed respectively are clearly defined by a law as Article 19, Clause 5 and Clause 11 of the Constitution mandates. In civil law, on the other hand, a successful claimant will have proved the defendant liable, and the defendant must then provide a remedy, often damages. Damages, general or special, usually are in monetary form. 7. Jurisdiction. Finally, the range of court in which actions may be heard also varies. In criminal law actions, the district court cannot try a case on indictment, as the circuit court and the high court can do. On appeal actions, a criminal action tried at the circuit court cannot be appealed before the high court, but straight to the court of appeal. However, in civil law actions, cases can be appealed from the circuit court to the high court. See the Court Act 1993, Act 459. See also the Court Regulations 2020, LI 2429, to help you identify the type of civil actions that may be commenced in the appropriate court. We shall later in our subsequent episode treat jurisdictions of the court. 8. Lastly, on the characteristics generally, the difference between substantive law and adjectival law is about where substantive law defines the right, the duties, the liabilities, and further provides any substantive issues arising between the parties. Constitutional law, the Constitution. Contract law, Contract Act 1960, Act 25. Property law, Lands Act 2020, Act 36. Criminal law, Criminal Offences Act 1960, Act 29, and company law, the Companies Act 2019, Act 992, are all examples of substantive laws. Adjectival law, however, deals with the procedures you need to comply with when bringing an action on any of the substantive laws. Usually, it is the adjectival law that gives us collateral or preliminary issues in actions. The Criminal Procedure Act 1960, Act 30, Evidence Act NRCD 323, the Constitution itself in certain provisions, and the Companies Act 2019, Act 992 in certain provisions are examples of adjectival laws. Practical directions from the court through the Chief Justice are also examples. The adjectival law is one of the reasons you need to first identify any preliminary issues arising in any case, and when briefing your cases before you attend to the substantive issues, as we indicated in our second episode on how to prepare a case brief on our series on the technical approaches to the studies of the law. Kindly check the video description for the link to that video. C. Where two classes of laws overlap, how does the application of the laws resolve itself? In order to understand and know how the court may treat actions where two branches of the law overlap in an action, it is necessary to know some of the laws that overlap. In civil law actions, usually the courts are confronted with actions that involve contract law and the law of tort, such as negligence or trespass or duty of care, or even in contract and property law fusing in the action. Again, the courts are at times faced with actions that involves both criminal offenses committed and any civil law release, such as breach of contract or law of tort actions. The question here is, how will the court probably resolve these conflicting laws in the action? See the cases of Dudley and Stephens for contract overlapping with law of tort, breach of contract, and negligence. See Amidu and the Attorney General, Waterville Holdings Limited, and Alfred Abisi Woyomi for contract law and constitutional law overlapping with criminal law. See also Fisher and Bell for contract and criminal law overlapping, and Gebi and Avalifo and the Republic for criminal law overlapping with constitutional law. In all, we need to appreciate that anytime criminal law overlaps with civil law in an action, the court will separate the two and consider them as two actions in one case, because the standard of proof as mentioned above differs from each other in these two branches of the laws. We'll leave you to find out in the instances where two categories of laws under the branch of civil law overlaps, how the court resolves the matter, and we will be excited to receive your submission on this task and give our remarks. Find out which of the branches does customary law falls, and where customary law overlaps with other laws, how does the court settle the matter? We will later treat common law and equity in our lesson on the legal traditions of the world. D. The essence of classification of law. Before we draw the curtains on today's video, let us take a look at the purposes of classifications of laws. Here, it is not our intention to provide in verbatim ways all the purposes of classifications of laws, but to indicate to you one best way to state the purposes of classifications of laws anytime you are asked to do so. In stating down the purposes, relevance, or importance of classifications of laws, or even the demerits or setbacks of classifications of laws, we advise that the points should be stated in divided groupings rather than lumping all together. In stating, put your points in the following partitions. 1. Advantages and disadvantages of classifications of laws to students and the learning of the law. 2. Advantages and disadvantages of classifications of laws to teachers and the teaching of the law. 3. Advantages and disadvantages of classifications of laws to legal practitioners. 4. Advantages and disadvantages of classifications of laws to judges and the adjudication of matters before the court. And 5. Advantages and disadvantages of classification of laws to the Ghana legal system in general. We hope our lesson today significantly assists you in your study of the Ghana legal system. We will subsequently bring you the remaining lessons on Ghana legal system and all the other core courses studied in the schools of law in Ghana. Thank you all for staying this long with us. Once again, we appreciate your time and comment. Please don't forget to subscribe to our channel, write your comments, like the videos, and share the link to all and sundry. We promise you more better, exciting, educative, informative, and entertaining content. Please take some time to view our other content as well. Thank you and welcome to the LawGH community. You can reach us via 059-290-1176 or email thelaw360gh@gmail.com.